Federal Bureau of Investigation, the G-Men. This is a Bureau of Scientific Crime Detection. New, modern, up to the minute.
And that new up-to-the-minute crime fighting is exactly why it is we're here. Welcome back to the channel, everyone, and today we're going to be talking about wiretapping and Olmstead v. United States. Roy Olmstead being the first man to be convicted using wiretapping. But before we go ahead and jump into the facts of the case today, do me a big favor. If you like the content on my channel, go ahead and hit that subscribe button. It really does help out. And if you like the video, go ahead and give it that hit on the like button, just till he turns blue. So let's go ahead and take a look at just what little old Roy Olmstead got himself into. So Roy was actually born in the late 19th century, and in 1907 landed himself a spot on the Seattle police force. Now, he was actually considered to be an excellent officer and was promoting quickly up the ranks. As most of you know, though, in the early 20th century, the temperance movement was gaining steam, the calls for prohibition were getting louder, and Washington State itself actually went ahead and banned alcohol before the federal prohibition came into place. Now, Roy, as a member of the police department, was tasked here and there with, busting up rum running and the like. And being a fairly intelligent man, he did the math in his head and he figured out that there was a good deal of money to be had in bootlegging. And so what did Roy do? He decided to bootleg while he was still with the police department. Unfortunately for him, he had been identified, and during a roadblock, he got fingered, no, not that way, and was fired from the Seattle Police Department in March of 1920, fined the not insignificant sum of $500, and quickly found himself without a job. Now, being the industrious man that he was, he found himself with a great deal of time on his hands and went straight into full-time rum running. He ended up being the general manager and main conspirator in a 73-man wide rum running ring that went from Seattle up into Canada. The case itself describes the enterprise as containing 2 seagoing vessels and others, the use of a ranch in Seattle, as well as some underground bunkers, and my personal favorite, an office complex complete with bookkeepers and a lawyer, because why wouldn't you have a lawyer if you're rum running? The enterprise was so large that if you had a bad month, Roy was only bringing in about $176,000 at the time, with a yearly intake of about $2 million. And here's where things get modern. 4 prohibition agents managed to wiretap Roy's phones. Now, there were phones in several locations, some in his office, some in some of the bunkers they had, and other hideout locations, mainly for the obvious use of communication. Now, the officers were smart. They didn't violate any laws when they set up the wiretaps. That is to say, they didn't go into anyone's homes, they didn't go on private property, they didn't break in anywhere. They hooked the wiretaps up on the lines in the streets near the houses and in the basement of a large office building.
You know, it's very easy to do with just these two little clips attached to the lead-in wire to your telephone to listen in on anyone's private conversation.
This particular aspect becomes very important in the court's Fourth Amendment analysis, which you'll see later. Having gotten themselves all hooked up, if you'll forgive the pun, the prohibition officers just kicked back and had a listen for several months. Over that period of time, the phone conversations they intercepted revealed a massive amount of information about locations, values, customers, the overarching enterprise structure, business transactions, everything. And it also went through the trouble of showing the relationship that Olmstead had with the local police, the Seattle cops that used to be his co-workers, including the quick release of some of the conspirators and under-the-table payments to the officers for their assistance and understanding. Obviously, since we're here, Roy Olmstead was arrested and convicted under the National Prohibition Act. And on his appeal, he made two distinct constitutional arguments. First, he said his Fourth Amendment rights were violated through the search or seizure of the phone conversations through the wiretap, and a Fifth Amendment argument against self-incrimination, basically trying to argue that because he was wiretapped, you couldn't use the statements he made over the phone against him because the government was listening in and he was incriminating himself. Taking a look at the analysis, the court determined, based on the pleadings, that the question they needed to answer was whether or not evidence between the defendant and others made through the private telephone conversations, which were intercepted by a wiretap, were protected under the Fourth Amendment, and whether or not taking that evidence and using it against him was a Fifth Amendment violation. To make those determinations, the court had a couple of things that it needed to do. First, it took a look at the order of operations, and no, it's not just good for math. So the court determined that to have a Fifth Amendment violation, you had to have a Fourth Amendment violation, because the statements can't be inculpatory and used against you in violation of the Constitution if the search and the use of the evidence through the Fourth Amendment is valid. Those two things can't go together. You have to have a violation of the Fourth to have the violation of the Fifth. So they started out with a Fourth Amendment analysis. And following that, they then looked at the Fourth Amendment case law up till that point. Now, it's important to remember the date on this case. It's 1920. The United States, being an English colony when we started out, started with that English common law. And up until about 1914, the American system largely followed that common law. Now, granted, our cases split off after we seceded from Great Britain and we have our own jurisdictions, but the concept remained. And in common law, there was a distinct difference between the legality of gathering the evidence and its admissibility in court. To say it, the police could violate your constitutional right, but that didn't mean that the court couldn't use it at trial. The thing would be that you would just need to sue the police department for money in relation to your constitutional rights. It doesn't mean that they couldn't use it against you in court. That changed. And the change came in 1914 with the case called Weeks v. United States, which we're going to get into at another time. But know that in the Weeks case, the exclusionary rule was developed. The idea is that an illegally gotten piece of evidence cannot be used against you in court. It is excluded. So if the police violate your Fourth Amendment rights to get the evidence, they then don't get to use it against you at trial. And that shift is the rubric from which the court, in this case, Olmstead, is viewing the Fourth Amendment. So taking a look at the various case law and keeping Weeks in mind, the court tried to figure out what it was that qualified for Fourth Amendment protections. So looking at that case law, there were instances where the police were breaking into private property and using evidence against people that they found, sneaking around and lying and then turning over evidence under false pretenses, going through your mail, all kinds of stuff. If they could manage it, they were probably doing it, all in violation of the Fourth Amendment. But when it was happening before Weeks, the courts were using it. So in looking at the Fourth Amendment language itself, the court sat and it said, okay, the Fourth Amendment protects people, property, papers, effects, things, tangible things, things that can be seized, grabbed, hauled off, all kinds of goodness. And not just the product itself, but let's say the example of the mail that they used. A sealed letter put into the mail is covered under Fourth Amendment protections. It's sealed, it's closed, the contents are hidden from plain view. And the court also went through a great deal of effort to explain that at the time, the Postal Service was a monopoly, and there were laws in place that the government was the only entity that could transmit mail, actual physical mail. So, how does that then play out against something like a phone call? The court completely distinguished phone calls and, say, telegraphs from letters, and the difference they relied on was the seizability, the actual physical, tangible nature of letters and parcels and people, as opposed to phone calls. The court said that there was no search, no seizure of Olmstead when the police wiretapped his phone because the evidence was secured by the use of the sense of hearing and that only. In effect, the court said that there was nothing for the police to seize, nothing for them to wrap their hands around. They could hear it, therefore they could use it. The court acknowledged in its evaluation that this was something of a new concern, but that it was unwilling to, as they say, expand the language of the amendment. The language of the amendment can't be extended or expanded to include telephone wires reaching to a whole world from the defendant's house or office. The court did go through the trouble, though, of pointing out to the legislature that should it so choose, the Congress is capable of passing laws. That's kind of what they're supposed to do. And if they thought that wiretapping was so important a concept, they could make it illegal for the police to wiretap. But it wasn't for the court to do it. That was not within their power. And as a result, the court found that because it's a phone call, it's not a tangible thing, wiretapping is acceptable and not a Fourth Amendment violation. And because there was no Fourth Amendment violation, like I described before, there was no Fifth Amendment violation.
Of course, in the famous Olmstead case in 1928, the Supreme Court, by a 5-4 decision, ruled that wiretapping did not violate the Fourth and Fifth Amendments, the Fourth relating to searches and seizures, and the Fifth, of course, to self-incrimination. But a great dissent was written. In fact, 3 great dissenting judges dissented in that case, Holmes and Stone and Brandeis. And the great Holmes said in this decision, and I read from page 470, "It also is desirable that the government should not itself foster and pay for other crimes when they are the means by which the evidence is to be obtained."
I should note that this actually changed in 1967 with a case called Katz, which we will also discuss at another time. So I hope that you enjoyed this case, and do let me know what you think down below. Was Taft, the judge that drafted this decision, correct? I tend to think not. It failed in its interpretations to consider the underlying meaning of the amendment itself. The whole purpose of the Fourth Amendment's protection against unreasonable searches of your person, papers, effects, houses, is this concept that those are private, intended to be secured articles and entities, not open to public view and not open for public evaluation, much like a phone call is. We don't anticipate strangers listening in on our phone calls, especially not in 1920 when cell phones weren't a thing. So I think Taft actually failed in his constitutional interpretation in this instance and went with too literal an evaluation of the amendment, which, given I'm kind of a plain language interpretation type person, is saying something. But let me know what you think. And again, I hope you enjoyed the video. Go ahead and don't forget to hit subscribe and like, and there's even that little bell that will tell you when I post videos. I'm trying to start putting things out about twice a week. So, keep an eye out, and I will talk to you next time. Be well, everyone.